Let's talk about a really important case for the Fourth Amendment. That case is Terry versus Ohio from the U.S. Supreme Court. It's from the year 1968, the Warren Court. This was 2 years after the decision of Miranda versus Arizona, and it's all about the idea of stop and frisk. Stop and frisk. It's been heavily criticized. Let's see what it's all about in this case. So, Chief Justice Earl Warren wrote the opinion. It's 8-1. Justice William O. Douglas dissents. What happened was you had this police officer, a very experienced police officer. His name is McFadden. He was a plainly clothed beat cop assigned to patrol Cleveland for shoplifters and pickpockets for 30 years. McFadden had become suspicious of the defendants Terry and Chilton. He saw them basically walk past a store window repeatedly and thought that was suspicious. He suspected them specifically of preparing to rob that store, or as the court put it, do a stick up. That's kind of a more classic term. But yeah, he watched them, he walked over to them, he identified himself as a police officer, and then he asked Terry and Chilton for their names. They gave kind of a mumbled response, and in response to that, Officer McFadden spun Terry around and searched him. When he searched him, he found a pistol in Terry's coat. McFadden testified that he only patted them down to see if they had weapons, but he did not reach underneath the clothes until he felt their guns. McFadden testified to the facts at a motion to suppress hearing. They moved to suppress this evidence, basically saying the way they got it violates the Fourth Amendment. It was an unreasonable search and seizure. It is a fruit of the poisonous tree, so to speak, and therefore it cannot be used against Terry at his trial. And on that motion to suppress, the trial court said no, they denied it. They said this evidence can come in. They said that McFadden was experienced and he had reasonable cause to believe that the defendants, Terry and Chilton, were suspicious, and for that reason, that they should be interrogated. So Terry was convicted of carrying a concealed weapon. Terry appeals. It ends up getting up to the U.S. Supreme Court. Chief Justice Earl Warren writes the deciding opinion, and he says, actually, there's no Fourth Amendment violation here. There's no Fourth Amendment violation. So this ends up being a decision which really grants a copious amount of authority to police officers. And it's kind of surprising coming from a liberal Supreme Court in the 1960s, especially after Miranda versus Arizona, where they're taking a more sympathetic stance to criminal defendants and a more expansive view of the rights provided by the Fourth, Fifth, and Sixth Amendments, etc. So he writes that it's not inherently unreasonable for an officer to see someone and subject them to limited searches for weapons. He writes, when there's reasonable suspicion that an offender is engaged or will engage in criminal activity based on some specific articulable facts, protection is a sufficiently weighty interest to justify a limited search for weapons before there is probable cause to make an arrest. He says McFadden's suspicion here was objectively reasonable in determining that he needed to do a limited search of Terry and in carrying out that search. It was totally fine the whole way. Moreover, he was justified by the government interest in detecting and preventing crime. And throughout this whole course of events, this chain of events, this story, there was absolutely nothing that dispelled Officer McFadden's reasonable belief that crime was in the air, that there was something going on, and that he needed to protect society from this. So yeah, there's a dissent from Justice Douglas saying, no, we actually need to require probable cause in cases like this in order for there to be an infringement on personal liberty, for that to be reasonable. So he has a different view of the Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Justice Douglas thinks there was a violation here. Chief Justice Warren thinks there was not. And yeah, that probable cause was not necessary in a case like this. Really interesting decision. As I said, interesting time period. Very progressive era in terms of rights for criminal defendants, but this was kind of an oddball one where it's like, officers get this discretion. They get this discretion to do stop and frisk, and they need some specific articulable facts to do so. Let me know what you think in the comments below. I hope this was helpful to you. If you're a law student studying criminal procedure, you're in undergrad, you're in high school. I read this decision in high school, actually. I hope it was helpful. I hope you can take it to the bank and get an A+. Like, comment, or subscribe to the channel. Thank you so much for watching. This has been The More the Merrier, and I look forward to speaking to you in my next video.